when it tries to catch up with technology. Technology has been a very difficult animal to pursue. And I want to congratulate the Honourable Member for St. George South in that he has now started us on a course of attempting to pursue a rather difficult animal called technology. I begin by saying that with an anecdote. A few years ago, there was a very famous wedding, or rather a wedding of a famous man who came to Barbados to have his nuptials performed. And sometime during the course of that famous event, a photojournalist called me to ask me what were her rights in relation to photographing that wedding. They did not allow her to come onto the premises where these Hollywood stars were gathered, and she had to assign the place a point of espial, as the writers would say, and secrete herself with a camera of very long length and try to use the term, invade onto the premises and capture those pictures for her newspaper. And she wanted to know what were her rights. And indeed, the person who sought to remove her from doing that told her that these persons had a right to privacy. I was able to say to her that we did not have in the laws of Barbados such protected rights of privacy that a person could photograph another person, unless, of course, that person intended to use those photographs for an unwholesome purpose, which would then have become a breach of the laws against defamation, that there really was not any protected right of privacy in those circumstances. And indeed, this is what this legislation condescends towards today. I think the Attorney General may have made some reference to it, that this is really capturing the issue of privacy. Now, I congratulated the member for St. George South because he is now using legislation, he is now using this Parliament to travel into an area which has previously been unprotected by the public law. Now, in private law, privacy has been a protected right. Of course, if one goes to a doctor and that doctor keeps records, if one goes to the hospital and that hospital keeps records, those records are protected against invasion by third parties, but that is not on the basis of public law. That is not on the basis of the law that we pass in this Parliament. That is on the basis of private law known as contract law, that when a person goes to the Honourable Member for St. Philip North and she holds that person's medical records, she cannot disclose those records to unauthorized persons, and she cannot do that because the private law of contract restrains her against doing that. So I've congratulated the Honourable Member for St. George South because he has now utilized the public law legislation to deal with this issue of privacy. And let us look, when one looks at privacy, the laws in relation to privacy, one is obviously the allied question is that of rights. I was inspired, let me use that word, I would have said impelled. I was impelled or inspired to intervene today, although I had not planned to speak, by something I saw on Facebook yesterday. A young man, well, a not so young man, I can't call his name, sir, I don't think I can, but he wrote something on Facebook yesterday. He apparently wakes up very early on mornings, like some of us, and he captures the sunset. And he places those, the sunrise. I was just checking to see if the Attorney General was listening, and clearly he was.
Yes, he's listening.
He is listening. You do those things to get people's attention.
Right.
He wakes up early on mornings and captures the sunrise. And apparently he complains that Facebook has told him that he cannot use those photographs in future. One assumes, therefore, that Facebook is saying to him that when he publishes those photographs become the property of Facebook. One can only assume that. I cannot repeat the language that he used in conveying his message to Facebook. But there again, the issue not only in relation to privacy, but the issue in relation to rights. To whom do those photographs belong? Do they belong to Facebook, or do they belong to, let us call him Mr. Griffith? Do those photographs belong to Mr. Griffith? Facebook, Your Honor, has been a creature of some monstrosity. It has made life very easy for those of us who want to find long-lost friends. It has made life very easy for those of us who have a message to send out to the world. And Facebook gives us the opportunity to send that message out to the world. Facebook has been an excellent medium of communication among private citizens. You don't have to own the New York Times or Barbados Today or The Nation or The Advocate to get your message out. And therefore, Facebook has made life so much easier for people who have a message to send out to the public. But I think Milton Friedman was one of the famous economists. He was one of the persons who say that there's no such thing as a free lunch. And inasmuch as Facebook has changed the lives of many in a very good way, there are some attendant problems that Facebook has caused and is causing in several countries. I know the Attorney General made a reference to Europe and the controls that exist in Europe. The European governments are attempting to control this phenomenon which we know as Facebook and which we love. But there's another side to what I call this monstrosity. It is a very large organization. And the Attorney General refers to Europe. I want us to focus on Germany in particular. Germany has been in the forefront of controlling this medium called Facebook, which, as I said, we're all happy for it. It is beneficial, but there are some aspects of Facebook which governments need to control. And I want to ask and appeal to the Honourable Member for St. George South to find at some point in the future, having brought this important legislation, to advance the legislation even further and to offer a means of regulation in the way that the Germans have done. And I will just bring a few examples as to how the courts and as to how the regulators in Germany have functioned in relation to this Facebook phenomenon as a vehicle of data and information and that kind of thing. Just a few examples. Facebook had a policy called the real name policy some time ago. In other words, if you went on Facebook, you had to give your real name. That was one of the terms and conditions that Facebook laid down to its subscribers. And the court in Germany ruled that that policy was illegal, that a person, indeed, part of our common law is that a person has a right to the use of a name. I can get up tomorrow morning and assume a different name, except that the state expects me to register that name. But Facebook felt that it had the power to stipulate for this real name policy, and the courts in Germany have ruled that that policy is illegal under German law. Now that is German law. We may or may not be influenced, or courts may or may not be influenced by German law, but the courts in Germany, who have been very active in relation to controlling Facebook, have ruled that Facebook could not stipulate that policy. Another example as to how the courts in Germany are prepared to deal with Facebook, and as I will pause and repeat at every turn that we are happy for the existence of Facebook. But if it is a monster, we are obligated as lawmakers with a duty to protect the interests of the public, to protect their rights, and to protect their rights of privacy. We are under a duty to ensure that this monstrosity called Facebook is ultimately controlled. A court in Germany has also ruled that Facebook must follow German data protection laws. And the court acknowledges that several parts of the Facebook's terms of service and privacy policies are against the data protection laws. Again, I commend this learning to my colleague who represents so well St. George South, that a lot of the terms and conditions of their contract of service between themselves and the subscriber, that the German courts have found that they are in breach of the German laws which stipulate for data protection. Now, we recently had an incident in Barbados, a quite tragic incident, and I will be very sensitive as I speak on this. In Germany some time ago, a young lady died in circumstances which were tragic. Indeed, in circumstances in which it was suspected that she committed suicide. And after her death, the parents of that child, of that young girl, sought to secure her Facebook account. And of course, Facebook felt that the parents of that dead girl had no right of access to that account. And the matter went to the courts of Germany, and the court held that that girl's private Facebook account fell into her estate. In other words, it became a part of her estate just as a diary would, just as letters would, just as, indeed as a book would. If someone writes a poem, if someone writes a book, and that person dies, that poem, that book, her letters, her diaries become a part of her property. But Facebook felt differently. Facebook felt that that account, at her death, fell into their property, that it became a part of their ownership. And the German courts told them no, that the parents who became her successors, entitled her beneficiaries, were entitled to that account. Why did the parents want the account, though? The parents wanted the account to satisfy themselves as to whether she had indeed displayed signs that led to suicide. And Facebook felt, on the other hand, that if that child, prior to death, of course, had had communications with other persons and had even mentioned the question or the contemplation of taking her own life, that Facebook took the position that it had a duty to protect those third persons with whom that girl had communicated. And the matter went to the highest court in Germany. And Germany's highest court ruled that, Germany's highest court ruled that that Facebook account became the property of the parents. In other words, it was the girl's property, and when a person has property and that person dies, all that they owned up to the point of death falls into their estate and it goes to their beneficiaries. So that was an interesting case which revealed the status of ownership of a Facebook account, that it belongs to the person, and at death, the person's estate has a greater right of access to it than Facebook itself. And these are all aspects of the law that we should familiarize ourselves with. I have restricted it to Germany, as I said earlier, and I'll say it again. You will find, Your Honor, that Germany and the German courts, and indeed the German Parliament, which has instituted a system of regulation of Facebook and these other giants, that you will find, sir, that Germany is in the vanguard of the movement that seeks to control these large companies that trade, largely speaking, in the exchange of data, in the exchange of information. Just another case before I close. The German court has also ruled against Facebook. Again, you will find, sir, that Facebook has been losing lots of cases in the German court. And I will pause and say to you that there are a lot of cases filed and pending to be heard on the other side of the Atlantic as well in the United States, so that the larger countries are seeking to protect the interests of the public when it comes to controlling and regulating the activities of these large organizations that trade in information. The German court has also ruled that against Facebook for the way in which it uses the email addresses to solicit new users. I had a conversation just a few minutes ago at lunch, and I was explaining to one of our honorable members that sometimes you exchange an email with someone, or you exchange a telephone conversation with someone, and when you visit Facebook later that evening, the person with whom you have spoken, their profile turns up as a person that you may know, and it invites you to enter into a Facebook friendship with that person. I speak with no authority, no expertise on these matters, but one really begins to wonder how integrated are these various media. One begins to wonder if these media are not able to exchange information beyond one's knowledge, that you speak by one medium and you find that you're invited to communicate with that person on a completely different medium. Well, here's the court in Germany prescribing the manner, prescribing against Facebook, I beg your pardon, for the manner in which it sought to use the email addresses to solicit new persons onto Facebook. And the court ruled that Facebook's terms and conditions of service in that context were invalid. Again, a Berlin regional court has ruled that Facebook is breaking data protection laws by collecting users' data without giving them the information they need to make informed choices. I press on in the short time I have, and I will compress a lot of what I intended to say. There are others who wish to speak. But privacy advocates have argued that the company is not transparent enough about what data it has and what it does with it. And there are echoes there of Orwell's Big Brother in the novel 1984. He wrote that a long time ago. And of course, he was speaking of a time to come in which we were all subject, all of our activities, our very whereabouts, would be subject to the knowledge and control of an entity that he calls Big Brother. One begins to wonder, with the state of communications in this world, if we are not really all subject, all of our activities, even within our houses, with the possession of a cell phone, with the possession of this thing called Alexa. One begins to wonder, how private really is our life now? How private is it? You go onto Facebook, you use your cell phone. To whom do you open up your conversation? To whom do you open up your whereabouts? To whom do you open up the content of your conversation? The question is privacy really protected in Barbados now, and indeed in the Western world where we live? I am pleased that the minister has included in this act a data protection commission. I do not know how extensive will be the reach of the commission, but I want to say to you, Your Honor, that Facebook and all these, Instagram and all these media do need to be controlled in the interest of the public, in the interest of individuals who almost live on them. They need to be controlled. I have visited section 70, I believe, of the Act. Let me visit that, Your Honor, for the purposes of this present debate. And section 71, I beg your pardon, speaks to the functions of the commissioner. And this is the portion that captures my attention more than any other when it says that the functions of the commissioner, that is to say the data protection commissioner, he will become a regulator as far as I'm made to understand. And his purpose will be to monitor the processing of personal data, and in particular sensitive personal data, and any other matter affecting the privacy of persons in respect of their personal data. Today, Your Honor, I want to say to the Honourable Member for St. George South, thank you on behalf of the public of this country, that he, Your Honor, has embarked on a course to protect the citizen against the might and the power. I do not know how extensive, beg your pardon? And in the other place, yes, the lady of House Business is reminding me that one has to acknowledge the Honourable Minister in the other place, and one is pleased for the solidarity the gender solidarity that exists in here. But to congratulate him and to be happy that the state is embarking on a course where the private law remained silent for a long time. As I said in relation to the practice of the Honourable Member for St. Philip North, that obligation to protect privacy was merely contractual. It was just a private arrangement between a doctor and the patient. But here is the legislature now taking this issue into the public domain, making it a creature of public law in which these duties must be adhered to, these duties must be maintained. So let me end by congratulating the minister once again, both ministers indeed, and to reflect that although this legislation, as all legislation, may become subject to challenge at some point, I want to encourage both ministers to treat this as the start of a journey, and that if there needs be, to extend this legislation into collateral legislation, into other legislation, which will further entrench the rights of the public in their relationships with these large organizations called Facebook and Instagram or whatever they are, because while they are of benefit to us, always remember, Your Honor, there is a larger benefit to that entity. That entity has become a billionaire almost overnight, and it has not become a billionaire just for the sake of its own existence. It has become a billionaire entity because of the ordinary citizen who subscribes. Every person who subscribes to those entities makes those entities stronger financially. And therefore, if they are stronger financially, all rights need to be protected and defended. So again, I congratulate the minister. I commend this legislation as the start of a journey, which is a necessary journey, but I wish to remind the public that it must take advantage of this legislation if it is so able to. And it must feel that it should have a right of access to the data commissioner, who will then report to the minister, but the minister is not a court. But I want to encourage the public to feel that the courts should be able or have a duty to intervene, that if their rights are infringed, if their rights of privacy are infringed, if their economic rights are infringed, that they should not be reluctant to go to the courts in defense and protection of their rights. I suspect there's a whole lot more that can be said on this legislation. I recognize the limits of time, and I believe that I should give others a chance to express themselves. And so, Your Honor, I want to say thanks very much. I'm obliged to you, sir.
Member for Christchurch West Central. Christchurch West Central.
Mr. Deputy Speaker, thank you. I want to first congratulate the Member of Parliament for St. George South, certainly. And I won't belabor the House too long. I mean, there have been sedulous discussions thus far on this bill. And I just want to add my 2 cents worth on behalf of the good people of Christchurch West Central. Data protection, Mr. Deputy Speaker, it's a very serious discussion. It seeks to augment how we, as an organization, as a government, how businesses practice the dispensation of data. It helps to protect and control that data and to ensure that it is used for the purposes it was intended for. And basically, Mr. Speaker, there are certain basic principles guided by this Act that we have to pay specific attention to. And these principles relate to how information is dispensed. And they must make sure that the information follows certain basic tenets. One, that the information is used fairly, lawfully, and transparently. In the Act brought by the Minister, it spoke specifically to ensuring that there is lawful and transparent use of data. That the information is used for specific and explicit purposes. That the information must be accurate, and where necessary, kept up to date. That it should be kept for no longer than is absolutely necessary. That it must be handled in a way, Mr. Deputy Speaker, that ensures appropriate use, and that there is a security aspect to this information. Now, these are the basic principles that govern the Act, and that helps to protect that information which persons hold close to their heart. It helps protect the businesses and certainly the government, because there are certain underlying factors, Mr. Deputy Speaker, that seeks to determine the information, how it is stored, and how it is dispensed. And that is called the sensitivity of information. Sensitivity as it relates to race, class, religious beliefs, political beliefs and affiliation, trade union membership, sexual orientation, health issues. All of these things help determine how information is stored and what you do with it. And it helps to protect both the consumer and the organization. And I'm saying that this law can come no time sooner than what is needed, because I'm going to say, Mr. Deputy Speaker, it is fit for purpose. We are in a heightened era of technology, where with a press of a button, information is spread across the globe. And it's very hard to determine who gets access to it, how it is controlled, and the catastrophic effects of it if there are no boundaries and protection put in place. And I say that we can only reflect on what happened only until recently in the banking sector to understand the need for us to put in place protective measures to protect the public and the business places, where persons, and you can't blame them all the time, Mr. Deputy Speaker, because half of the times they do it sometimes in a flippant way, an ignorant way, put their information on social media, on Facebook, on Twitter, and all the other networks that you would know about, Mr. Deputy Speaker, because you're a young man, but maybe a little older than me, but young in spirit. And I'm saying that, Mr. Deputy Speaker, this information is put out there, but in this tech-savvy world that we live in, there are persons whose sole purpose is to utilize that information for personal gain, or for malicious gain, or for financial gain. And we have a duty to protect the public from itself. And I am making a special appeal, in as much as we bring laws in this August chamber to help determine how information should be dispensed across this country. I am appealing to Barbados to have a sense of ownership of their information and be responsible for making sure that the information they're put out there is information that they would expose to all and sundry. Because as I said, look at the example what happened to the business in the banking sector the other day, where persons, unbeknownst to them, were putting information on social media and other networks. And this information was accessed, and you know the story goes on as to what happens. And then they put their hand in the air, Mr. Deputy Speaker. But we are sometimes partly responsible for the outcome of these events. And I'm saying to persons in the same way we are encouraging the banks, commercial banks and other places to make sure they put protective measures in terms of cyber technology. We are asking persons, especially those in earshot in Barbados, and earshot certainly, to ensure that they do all that is possible to protect and secure their personal information. Oftentimes you go on websites and they're asking you to send your credit card number or your ID number because you win some prize. All these are different devices that persons that are involved in cyber burglary and all these other cyber devices. Those persons are trained in this area, and that's how they are going to prey on the most vulnerable. So you're asking people basically by this legislation to help ensure that they move hand in glove with agencies to protect themselves. Because at the end of the day, this is the responsibility of government. But we have to ensure that persons understand also by their action that they have a responsibility as well to do what they have to do to protect themselves. And also making a special appeal to those in the banking system. And this may not be tangential, but Mr. Deputy Speaker, oftentimes they go in the bank and they see long lines. And when they look at some of the persons in the line standing up, the disabled community, I see pregnant ladies, Mr. Deputy Speaker. I see the elderly, those past the twilight of their years like you, Mr. Deputy Speaker. But I see some nonagenarians standing up in the line, Mr. Deputy Speaker, for long hours. I am making a special appeal to commercial banks to have a separate line for these individuals. Because it's how we look after those persons we consider the most vulnerable. Those challenged people in the society. And oftentimes, when I go into banking institutions, I see these persons in line like everyone else, waiting, sometimes crying out in pain. And we must have a sensitive and listening ear to those persons because they are part of our society, an important and integral part of this Barbados. And it's how we treat them that will determine our basic existence. So in the same way we talk about technology, information, data protection, I am saying all these things mean absolutely nothing if we do not talk about people and the involvement of people, especially those that are challenged. Mr. Deputy Speaker, I want to end, because I said I will make a short presentation, by talking about the protection of medical information. And I heard the Minister of Health and Wellness spoke on it earlier. But as a pharmacist myself, a former pharmacist, sorry, I must say, but the profession here, it never leaves you with me that. I'm sure that I'm going to still give some advice to some of those fellows who may want some assistance. For whatever reason, Mr. Deputy Speaker, I'm not talking about you, sir, but I'm saying that it is important when information is passed from the doctor to the pharmacist that that information is protected. Because Barbadians hold the medical history, the health, and the illnesses close to their heart. It is sacrosanct. And the way how that information is protected and how it is dispensed, Mr. Deputy Speaker, I am thankful to the Member of Parliament for St. George South for bringing legislation that helps to protect both the patient and the physician, because it will speak to the way how that information is treated, the protection of that information, those who are working in those areas, whether at the clinics, whether in the pharmacies, those persons must now fall under this new category of data protection. And I'm saying to those persons that do everything in their power to ensure that there is adequate cyber protection in terms of the software. Because it is all right for us to talk in here in this August chamber about protection, but we must also advise and encourage businesses to come with the latest software to help protect our consumers and the customers. And I'm saying to those in the medical field that they have a responsibility to ensure that medical data is not exposed to all and sundry, and that it is kept only for those that are supposed to be using that information. And I'm asking persons of Barbados that we will bring new legislation in this August chamber that will seek to protect our country. Barbados is now voted 129 out of 190 countries as it relates to the ease of doing business. We have to now get with the times. We have to be on par with what is happening in the international market. And we are saying that data protection is all across the world. The United Kingdom, you name it. Because we have a responsibility to protect our citizens, our institutions, and the government at the same time. And we will be bringing legislation that is fit for purpose, that has the vision of this country as we go in to a new sphere of development. And I'm saying to the Member of Parliament for St. George South, job well done, continue. And I also want to make special mention, I also want, as we're coming to know, to the good lady from the upper chamber, my friend, Senator McConney, the Minister, responsible for innovation, science, technology. And I want to give her a round of applause today in this August chamber. But it shows that we are working with every sinew in our being, Mr. Deputy Speaker, to ensure that we produce the best for Barbadians, because we believe that Barbados is the best country in the world. And the data legislation like what is brought before us will only seek to enhance our reputation as a country in the 21st century. Mr. Deputy Speaker, I am obliged. Thank you.
You're welcome. Member for St. Philip North.
Thank you, Mr. Deputy Speaker. In my usual fashion, I'll make it short and to the point. I want to commend the member for St. George South on bringing the bill to the House, and he could only agree with it. I want to bring a few things into focus, though. As I was speaking to the honourable member a few minutes ago, he basically made me realize the importance of this bill even in the private sector, in terms of the doctors out there. It not only applies to the public sector, but it applies heavily to the private sector. And I am hoping that it extends to that either now or in the near future. In the private sector and indeed public, there's a flow of information. It starts at the patient and it may go to a nurse and eventually comes to a doctor. From the doctor, you send information to the lab where you have testing done. From the doctor, you also send information to the pharmacy as our in-house pharmacist. By pharmacist, by any other name, he will always be a pharmacist despite the fact he says he's no longer a pharmacist. That will stay with him forever. But information is also disseminated to the pharmacy. Sometimes information is disseminated to the lawyer. All of this, or most of this is always sensitive. For instance, the lab gets information on tests that we may want to do on sexually transmitted diseases, including HIV, herpes simplex. This is sensitive information. The lab might also have information on blood tests, paternity testing. This is also information that is heavily protected, and I'll give you some examples later how that comes into play. The pharmacy now, they get to see the medications, the prescriptions that we write, and oftentimes, if not all the times, medication that we prescribe links directly to the diagnosis of a patient. So confidentiality spills there as well. Information about the same STDs, the pharmacist would know. Then there's a medical history that we're all familiar with. There's history like psychiatric history, which is still somewhat of a stigma, like HIV and in some quarters, cancer and diabetes. is still heavily stigmatized in Barbados. This is important information. Simple things, or what might seem simple to people, like a woman that gets a termination of pregnancy. This is something that is important and should be held in the strictest of confidence. Pregnancy tests. It might seem simple, but I have had cases where relatives or family members or strangers may have called my office seeking information on the pregnancy test of a woman. I even had an occasion, true, where a gentleman brought in urine to my office to have it tested for his girlfriend for pregnancy. These things are important. I want to bring up something when I was speaking about the lab, the importance of HIV testing with respect to patient, client, doctor, lab privileges. I don't know if it's still this way, but HIV testing is we usually send in the blood under a code. The patient is never mentioned by name. And up to a few years ago, I hope it's still so, one doctor in the entire island, used to be aware of the HIV test, which is good. The problem I have with it, though, is that it has to be buttressed by the location that we use for the treatment of HIV-positive patients. Right now, I know private doctors deal with it, but it's also done in a central location in a part of the island, and I have had people that told me that they're sitting outside to see who's entering, to see who may have HIV. It sounds funny, but it's true, and it could affect the lives of so many people. I do not really know what I can offer, what I can suggest to make it better, other than to integrate it into the other clinics that already exist in the public sector. As we spoke about before, the pharmacy has important information, and not only for data protection, I think it's a good idea that we'll be able to share information, whether it be private or public, the doctor with the pharmacy. A few years ago, I wanted to check on a patient's medication, for instance. Called the hospital pharmacy, and the pharmacist broke down in laughter. They had no computer record of the patient prescription. I'm hoping it's better now. No computer record of the patient prescription. The patient, in most circumstances, could not remember the name of the medication. So I'm hoping with this data protection bill, and that it goes hand in hand with data supply, for want of a better word. Medical reports. Imagine if it could be helpful. Might not be too bad in the public sector, but in the private sector. The public sector, imagine if we could have a system where the medical records are on computer, so that when a lawyer or patient asks for a medical report, the information is right there in front of you, no fear of losing notes, so that legal matters could be dealt with as swiftly as possible. Apart from that, I had the experience of waiting 4 hours in the outpatient clinic a couple Tuesdays back. 4 hours. One of the reasons being is that the notes was lost. 4 hours. The other reason is that since I was practicing at the hospital somewhat 22 years ago, you are given 2 appointments, a 9 o'clock and a 2 o'clock appointment or 1 o'clock appointment. So 100 people have a 9 o'clock appointment, another 100 have a 2 o'clock appointment. Believe it or not, in 2020, this is happening. It makes absolutely no sense. You risk a whole day missing at work, which in my case, I did miss a whole day at work because of this. The government's work, by the way. People have to call in sick. People with young children have to be away from them. But there must be a better system, and the computer and data protection, data dissemination can only help with this. I mean, it's unacceptable. The other issue I had down there, the doctors complain of supplies, procurement of things like gauze and gloves and so on. As it stands now, I think we're moving towards getting it computerized, but as it stands now, I could walk into the supplies, pick up what I want. I suppose you can sign. But at the end of the day, nobody knows where the gauze is going, where it's coming from, how much it is. So things like that, along with the data protection, I think it would come in handy for these things. The polyclinics, I know in at least one of them, maybe more than one, it has started where we have patient notes on file, on computer file. This helps in the handling of information back and forth from hospitals to doctors. There are so many times, and in the public sector, where we would love to have at hand the blood test quickly for a patient, X-ray results quickly for a patient. It could mean the difference between life or death, between giving a medication that does not get along with another medication they're at. So I'm pleased to see we're moving towards this. Apart from, I'm seeing in the bill mention of protection of children. I think this is important. Of course, parents have to be involved, parents have to give consent. I'm wondering what applies to some of our government institutions like the Government Industrial School. I can't help but bring it up. I am aware that sometimes, I should say alleged for the legal minds in here, tests are done on children, minors, without the consent of parents. I strongly object to it. I think it needs looking into urgently. Urgently, it could put a child in great danger. These children matter. At the end of the day, children still matter. And we need to protect their privacy, ergo the parents' privacy as well. So, Mr. Speaker, these are some of the things I want. As I promised, I was short. I could only support the bill that the member for St. George South would have brought. I hope and pray that it extends to the public sector as well. Still, a doctor will always be one. And I'm hoping that it applies to us as well, where we can get information as we would want, important information from the polyclinics, from the hospital, from the laboratories, everywhere. So I am lending my support. Thanks for your time.
You're welcome. Member for St. Michael West Central.
Mr. Deputy Speaker, I rise to support the bill before the Honourable Chamber, the data protection bill. Mr. Speaker, Deputy Speaker, I think that this bill will transform how personal data is managed in Barbados, and it is following through. I believe the Attorney General would have made mention of this. It follows through on the EU regulations. I believe it was 2016/19 regulation, which came into force in May of 2018. Effectively, what the bill sets out to do is to confirm, or to protect, I should say, personal data for all users in Barbados. And I believe that this is long overdue, because there has been, or there is, I should say, a Computer Misuse Act. And even though there's a Computer Misuse Act, and I believe that this Barbados Labour Party and its previous administration would have piloted as a government the Computer Misuse Act in its early days. So even though we had a Computer Misuse Act, we have one, this bill will reinforce and essentially create the operating framework for the government to proceed with general data protection and misuse. Although I must say, Mr. Speaker, that I believe in the not too distant future you may have to bring even more amendments to the Computer Misuse Act. I won't go into detail on this particular occasion, Mr. Deputy Speaker, but I think that time is overdue, long overdue, for key amendments to be made to the Computer Misuse Act. But like I said, the bill before us is far-reaching. Indeed, following through from the EU regulation, it is perhaps the most progressive and far-reaching regulations for the use of personal data. Within the EU, as we know, it relates not only to EU citizens, but also persons worldwide. The genesis of this, obviously, is the GDPR, the General Data Protection, and it makes it clear that organizations will be held accountable for personal data that they hold. And this obviously will include, for example, if there are any corporate acquisitions, if there are issues in respect of putting in place proper accountability measures to access personal data. And even though an entity is being acquired, it still mandates how data should be managed and or protected. Mr. Speaker, we all accept and we know that personal data has real value to organizations. And if personal data has real value, it therefore means that employers and other organizations will have a legal duty to ensure its security, just as we do with any other assets, Mr. Deputy Speaker. It is known, for example, within the European environment, that there's a ICO, the Information Commissioner's Office, and that office is mandated to take strong actions, Mr. Deputy Speaker, when it becomes necessary to protect the rights of the public. And data protection in the UK certainly has greater powers to even find companies. I know the Act also, the bill before us speaks to that as well. But I'll give you an example, and I believe, I'm not sure if other members alluded to this, but you have an example not so long ago, in fact, very recently actually, you had a situation where British Airways was fined £183 million for a data breach by the Information Commissioner's Office in the UK, the data privacy regulator. And I am also aware that there's a pending case against a major hotel company, and that they're facing the possibility of about almost, I think the figure is £99.2 million. So if we begin to understand what is at play here, even within the European environment, we will begin to understand the critical value and importance. Now, remember, Mr. Speaker, that this also applies to persons, not only EU citizens, but persons worldwide. And I will give you a very basic illustration of why I say worldwide. You have, for example, in the hotel industry, where tour operators now have to put into their contracts with hotels that they will be bound by the model clauses within the GDPR EU regulation of 2016/19. Other tour operators have also had to issue an addendum to adapt the model clauses set out under EU regulations, so that potentially you could have a cross-border reach and implications, and therefore the bill that is before us will help us to not only manage data protection, but also to put in place the Commissioner as outlined in the bill to help us avoid such breaches. Now, and I will say this because I work in hospitality, that there is a lot of work to be done in Barbados. I'm fortunate that I work for a company. We have a data protection, a data privacy person who is employed by our company who's responsible for this. And the amount of work that that person has to do in respect of this matter alone will open the eyes of many in Barbados. And it is a very serious piece of legislation, but also the EU regulations, because like I say, it has cross-border reach, will have a substantial impact on Barbados. I also believe, going forward, especially those with cross-border reach, that you will have to have not only central government, but organizations publishing a privacy statement, because it will also assist people in terms of the communication. I also, and that would have to publish, I should make the point, Mr. Deputy Speaker, on websites so that people can see it. There's also going to be, in my judgment, operating requirement for most entities in Barbados who manage personal data to employ persons to just supervise this function. So herein lies another opportunity for persons to be employed in this in a similar position. I call it data protection officer or data privacy officer, who will be able now to help organizations manage compliance and also to steer clear of any potential lawsuits. And believe you me, I only cited two. The Honourable Member for Christchurch South cited some others as well. but breaches in respect of data privacy, especially if you have worldwide reach, could be severe for even a small company and small country. But compliance will also extend its reach, Mr. Deputy Speaker, to institutions, medical doctors, hospitals, sir, schools, those organizations that hold a lot of data. And I will also tell you that even for the National Insurance Scheme, where you have a lot of personal data, that now you will have a situation, I already have it on the agenda for the next board meeting of the National Insurance, because I was thinking ahead, where you will have to have almost like a data privacy officer, or some people might say a data protection officer, to help engineer and assume compliance with the legislation. Because like I said, it will have very wide reach. And I only cite National Insurance because that is, for example, an institution that will have, that they have a lot of personal data, they will have to manage data, and that they will have to be in Barbados, based on the bill, a new set of policies and procedures, or processes if you wish, in order to manage this business of data protection. Mr. Speaker, right to access, I believe that's settled in clauses 10.1 and I believe 10.2, where I think essentially we're going to have to focus on how personal data is transferred, especially to another country or to an international organization. And that is something that I believe the bill speaks to very clearly. But what is clear to me, sir, is that this bill will have substantial value, not only to Barbadian organizations, but to Barbadians. And that Barbadians, once with the passage of time, and when it comes into force, will have that added measure of protection, knowing that those persons who hold their personal data, or who house their personal data, that they will be duty-bound, including banks and other institutions, that they will be duty-bound to manage information in such a fundamental way so as not to, or to avoid, wherever possible, security breaches or breaches with data. Mr. Speaker, the other thing is how we dispose of data. There is obviously procedures. The GDPR sets out very clearly how you have to dispose of personal data. The bill before us as well speaks to it. But that is something that for too long we've not taken, in my opinion, we've not taken too seriously in this place, in this country, where you can dispose of data without perhaps following key procedures. I am happy at long last that even my constituents in St. Michael West Central will be very happy to know that when they have personal data, that their data will not be taken and just thrown in a garbage to be disposed, that there will be no effective and proper policies and procedures to govern the disposal of personal information. And I think that is a step in the right direction. I'm not going to speak to law because I'm no lawyer. I can't trespass on my friend, the Honourable Member for Christchurch South. He's done a wonderful job in terms of, he went far, Mr. Speaker, the way into international jurisprudence. I believe I got it right. Yes. But that is well covered. But there are also aspects of personal information that we also have to be mindful of. You have situations where your information could end up elsewhere, and you don't know the source of the information or the source of the dump. You have a situation, for example, where bank accounts are being compromised. So that this bill now, with additional layer of computer security and cyber security, it will also now place a responsibility on institutions and organizations to ensure that they manage, fundamentally manage how data is protected and managed. And I know that as a result of this bill, that, like I said before, you will have, must have persons employed in various positions now in order to monitor and manage data protection. And I think it's a good idea to do so. There's one point, Mr. Speaker, that I wanted to make, and it has to do the point clause 19 of the bill. And I believe that we may have to, it would be, I may rephrase it and say that I think it would be useful to have guidelines to assist people in how to communicate in terms of data protection. And that's the only one point I will in respect of the legislation I believe we could look at if the persons are so minded to do, so that we can see how best we can communicate. But I believe that, once again, this is a first for the Barbados Labour Party. It's a first for this government in terms of setting out the appropriate framework for the protection of data and obviously for the dissemination of data. And for that, Mr. Speaker, I want to thank the other minister from the other place who would have been responsible for a lot of work, as well as the Honourable Member for St. George South, who would have piloted it in here today. I want to thank them. It tells me that the Barbados Labour Party, that I'm very happy and proud to be associated with, is going in the right direction in terms of bringing bills to this chamber that will have a long and but meaningful impact on the lives of the people who sent us to this Parliament. Mr. Speaker, those persons deserve our protection. They deserve our protection in terms of legislation that we come in here almost every Tuesday now, Mr. Speaker, to protect them and to protect their interests. So that I say to all Barbadians, this is a good step. There are persons and companies in Barbados who are already following the GDPR model. So this will not be new to some people, particularly those in the hospitality sector, Mr. Deputy Speaker. It's not new. But what will happen, Mr. Speaker, that I think that those who've been involved in data privacy and data protection would also, I think, go a long way in helping other entities who probably would not have as much information. And I also make the point, Mr. Speaker, that this proposed legislation, this bill, sir, will have far-reaching implications for the protection of data. And I know that if there's any point in time where there were persons who thought, well, I don't know who got my data, how this information was obtained, especially when you have institutions and organizations asking you a lot of questions. A simple thing, Mr. Speaker, is even a simple job application form. How you manage that now will be called into question. And you also have situations where you're going to have to publish, like I said, a privacy statement, and that you're going to have to communicate that even on your intranet. Even the way how you construct contracts of employment in Barbados, that too will change. And then how you have the statements that will have to be either added to your employee handbook, or what you call the staff handbook. How you deal with those matters, Mr. Speaker, you will have to articulate how these things are incorporated. Mr. Speaker, I don't want to boast, but the entity that I have the wonderful opportunity to work for, we already have these things in place because, of course, we have a little bit of foresight too. But we have these measures in place to help us protect not only data for our customers who come to Barbados in accordance with, obviously, to operator requests, but also data protection as it relates to employees. So when I say this thing is going to have far-reaching consequences, it will. I can go into every other aspect. For example, I can talk about national insurance, how it will affect that, how it will affect financial institutions, but I'm not going to bore the chamber, Mr. Speaker, with those examples. But what I want to say, that down to the very basics of contracts of employment, employee handbooks or staff handbooks, as some people refer to it, there will be procedures that will have to be followed in order for us not to be breaching data privacy. Sir, and on that very brief, and on with those very brief remarks, Mr. Deputy Speaker, I'm obliged.
Thank you. Welcome. Member for St. Michael Southeast.
Thank you, Mr. Deputy Speaker. I rise to lend my support for this piece of legislation being introduced, the Data Protection Bill of 2019, and to endorse the comments of several of the speakers who have gone before me today, and also certainly last week when the bill was introduced by the Honourable Member for St. George South. And obviously its origin was in the other place. Senator McConney would have been responsible for the introduction of the bill, and those who would have worked in the preliminary stages in the select committee. It is evident that what is before us this afternoon, certainly, Mr. Deputy Speaker, is a piece of legislation which has certainly been thought through, by those who would have had the opportunity to participate in it. But in terms of its timeliness, I think it is a recognition of where we are in an age of technology. A couple of years ago, I'm sure, a couple of decades ago, none of us would have imagined a world where we would have been talking about data protection or what we do with information. Information was readily provided, it was readily supplied, and in a lot of cases, no one really was too concerned about what was done with it or who were the persons who were responsible for that information or even where it was stored or archived. What is interesting, Mr. Deputy Speaker, is I recall on my entry into the Ministry of Education last year, doing a walkthrough of the premises and discovering that there was a records department in the Ministry of Education. And in that department, there were a number of filing cabinets. In those filing cabinets are a number of documents, files, records of various individuals, whether it's persons within the teaching profession, the administration, in relation to students. There are records that in some cases are not digitized as yet because we are in the second batch for the digitization process that will take place, I believe, quite soon. But the reality is, Mr. Deputy Speaker, is that what struck me was that we were operating in an environment where a lot of the information that the Ministry of Education certainly has control of was not digitized, but it was also being stored for the most part in a manner which was in some cases questionable. Now, the reality of the situation is that previous administration would have spent large sums of money cleaning files and restoring them back into the same storage compartments that they were previously in, rather than taking the more progressive approach and ensuring that things like data protection legislation that would govern how people actually use the information, but also moving towards a direction where we look at the overall digitization costs, that would perhaps have been in the better direction in which, as a country, we should go. Because I do believe that spending money trying to clean files that are improperly archived or in areas which present some environmental issues for staff is not necessarily the best way to go. And I certainly have made the case within the ministry that we have to urgently seek to address these challenges. And I believe this is across other ministries as well. I don't think the Ministry of Education is any different from any of the other ministries, because we have a serious problem in relation to files. There are files that are in the ministries on persons in relation to their academic performance over the years, and this is from infants all the way through. You have personnel records that are existing within the ministry. So there's a large set of information and a large volume of information that exists within the Ministry of Education, which now we must move in the direction urgently to be able to digitize, because a lot of that information is sensitive personal data as well. Now, while over the years we've had the benefit of technology, obviously the appropriate regulatory framework has not certainly evolved in terms of catching up with time. And I believe that this piece of legislation allows us now to look back at some of the practices that have evolved over the course of the previous years, to be able to put in place now privacy statements that are necessary. For instance, when you're gathering information from parents within educational institutions, whether you are gathering information from your staff in relation to their personal administration files. It allows us to be able to have a framework within which persons can be guided in relation to not only who is supposed to handle the information, but also what is supposed to be done with the information. And I think more importantly, the legislation also speaks to the length of time within which the information is also supposed to be stored and supposed to be kept, and the manner in which it is supposed to be kept. The thing about it, Mr. Deputy Speaker, is that where we don't have penalties, sometimes people do not take things as serious as they should. And it is always important that in dealing with sensitive information, you operate within a framework where people understand that there are consequences for breaches of confidentiality, but also dealing with confidential information in a manner which is not appropriate. Now, that Mr. Deputy Speaker, requires that if we are going to speak on the one hand about legislation that is going to protect data, then we also have to accept and appreciate that there is another cost factor that has to be taken into account by various ministries in particular across this country in dealing with the archiving of this particular legislation. And thankfully that commitment has been made by this administration to be able to start the process of digitization. I must tell you that within the Ministry of Education, we face the challenge of the doubling up of clerical staff because of the retrenchments. And it has presented some difficulties not only internally within the ministry, but it has presented some difficulties within the educational institutions as well. This is a factor that can impact, and no doubt has impacted, on the ability of information to be gathered in a timely manner, for it to be entered in the requisite database, and for it to be stored properly. It therefore means, Mr. Deputy Speaker, that the acceleration of the digitization process must happen if we are going to ensure that we are compliant with this legislation as well. Because it is one thing to have the legislation, but you must also understand that legislation and the requirements of legislation also bring with it a secondary cost as well that needs to be taken into account. Now, I remember, Mr. Deputy Speaker, a few months ago, I had the opportunity to speak to Senator McConney regarding assistance for the Give Back program and seeking some guidelines for her in relation to information that the Ministry of Education was seeking to be able to acquire from our students in tertiary institutions. And I must tell you, I was tremendously impressed by the guidance that was given, particularly as it related to data protection. Again, there were very specific things that were highlighted in relation to what are we using the information for, who is going to be handling the information, into whose hands as a third party this information is likely to be accessed. We had to discuss things like permissions, who would have the requisite permissions to be able to access pertinent information relating to students. And again, I think, Mr. Deputy Speaker, that is the type of exercise that across ministries and certainly across all of the persons who are affected by this legislation, that must now take place. We have to ask ourselves some serious questions in terms of the systems that exist, whether those systems are now compliant with this particular legislation. And if they aren't, then I believe that the Ministry of Innovation and Science and Technology now has to also put in place a program for sensitizing and educating persons in relation to what are the requirements of this particular piece of legislation. Because it may seem to some as though it may be a bit onerous in terms of the requirements for under the legislation, but the reality is that if we are going to be compliant, then we have to take into account the various provisions that are currently within the legislation if we are going to meet the tests and eligibility criteria for storing information. Now, within education, a child is not, obviously a minor is not going to be able to give consent for information to be obtained. Usually it is the parent or the guardian who usually will supply that information, and the legislation is very specific in relation to the lawful process that takes place. Is really that the parent or the guardian of the child is the person who will give that requisite consent for data to be stored. Now, the interesting thing, Mr. Deputy Speaker, is that in education, we have found ourselves in a situation where information may be requested at the beginning of a school term, information changes, and those records need to be updated. Again, I believe that sensitizing parents and certainly guardians as to the importance of keeping information and records on students up to date is critical, and it is going to be critical moving forward. It also requires that people understand that the Ministry of Education is responsible for collecting information on academic performance of our students, and therefore we have systems in place to be able to gather information as well. Not everyone has access to that information on a particular student, but the reality is a system is only as good as the information and the data that is entered. So therefore it requires for us to be able to ensure that the persons who enter that data do so in a timely manner, do so accurately, but also that they themselves are sensitive to the information that is also collected at any point in time. In the ministry as well, Mr. Deputy Speaker, there is also other sensitive information that sometimes comes to hand, because we're well aware that the dynamics of society sometimes dictate that you have a number of, whether it is issues with children, challenges at home. There's a lot of sensitive and confidential information that from time to time will fall within the Ministry of Education. Again, this is all data collected, which, if it hasn't in the past been clear who should have access to that information, this particular legislation gives us the foundation and certainly the basis upon which now that clarity can certainly come. And I believe that the whole concept of privacy notices, ensuring that parents, when they're supplying information to schools, that they are told upfront what they are supplying the information for, how that information is going to be used, even things that are as far-reaching as persons who have gone off to tertiary institutions. There is a process right now in the ministry where persons send back in information via emails regarding their academic performance. All of that constitutes data and will now be covered by this particular piece of legislation. It therefore means that, yet again, we have to be sensitive with the information that is shared. We have to be respectful of the person's personal data and put systems in place to limit the number of persons who have access to that particular data as well. I have grown up over the years hearing about how things fall off the backs of trucks. Even in this place, I have had the opportunity on several occasions to either be privy to such information falling off of the backs of trucks. And it is regrettable, because it now requires, with this legislation, that people are more sensitive as to what comes out of a ministry, what comes out of a company, because it has a greater impact on persons in terms of the type of information that is shared and certainly confidential nature of the information. I think when I speak to sensitization too, I would hope, Mrs. Deputy Speaker, that as we sensitize, there are things that we have to sensitize persons to that before we would have taken for granted. A couple of years ago, we didn't have to sensitize students, or we didn't think we had to sensitize students to the use of a cell phone policy. Persons gave cell phones. It was the way that students would communicate with their parents, and nobody thought so far ahead that a student would then be using a cell phone to record a fight, upload it to social media, and circulate it. And then both students and adults would be circulating it all over in the public domain. We have now reached a point where, while we may not be happy that we've gotten to this place, there are a number of things that we have to regulate by putting them in writing. We can no longer take for granted that people know, that students know, that teachers know, that parents know what they are and are not supposed to do. And unfortunately, if that time has come where we must reduce everything to writing for the avoidance of any doubt in anyone's mind, then I believe that we have to certainly seek to do so. Now, I believe that the introduction of protocols for security breaches is also highlighted in this particular legislation. I believe that across the various institutions, ministries, and certainly in relation to companies, that you will start to see the emergence of protocols in terms of who can handle information. It also, in this legislation, speaks to the issue of disposal of information and a disposal of records, because in other countries you have a time frame for the disposal of information, but you also have a clear schedule in terms of who can dispose of the information. And again, we have now come to that point where we have to address things that, again, were commonplace before, that some people understood. But in today's society, there are clearly things that some people do not know and must now be reduced in writing and must be reduced to policy for the avoidance of any doubts. The other issue, Mr. Deputy Speaker, is that some of the sensitive information that is often, or that will form the basis of data protection, especially in education, relates to information that has to be shared between various social care ministries as well. The Ministry of Education does not operate in isolation. It is dependent and has to work very closely with the Ministry of Community Development. It has to work with the Social Welfare Ministry and the Child Care Board. As a consequence, even the Royal Barbados Police Force from time to time, if there are matters that involve any sexual offenses or sexual harassment. The reality is, therefore, that even inter-ministry, you will also further see the development of protocols that govern the sharing of information that will allow not just the Ministry of Education to get the job done, but also that allows us to be able to work with partner ministries in order to be able to bring resolution to certain matters that may present themselves. And it is important that those protocols are done in compliance with this legislation, but also to ensure that persons who are concerned that their information is likely to be shared, that information is done so in a respectable and a confidential manner. Now, Mr. Deputy Speaker, the other issue that I would want to raise, because I believe my colleagues have pretty much, I won't say exhausted, but I think that they've spoken widely in relation to this issue. But the other thing that I would want to raise is the issue of the boarding of equipment, because in particular computer equipment across the secondary schools and certainly many of the offices across Barbados and the ministries, we have a serious problem in relation to the pace at which equipment is being boarded. Now, a lot of this computer equipment, for the most part in the ministries, it needs to be wiped, it needs to be cleared in order for it to be properly disposed of. And certainly in education, I have lots of schools where there is equipment in rooms in storage. Even within the Ministry of Education, we have equipment as well. I would just want to make the call again to my colleagues to ensure that that process is sped up, because it is not so much just alone the issue of data that is on these devices that needs to be cleaned, but I believe that we also have to look at the issue of what we are storing. Just as we have files that are being stored that can create some environmental problems for our administrators or educators or students, similarly, we have a problem where dust is also created as a consequence of having substantial amounts of computers in any one location. And I think we all know the problems that have been presented within the various educational institutions in relation to environmental problems. So I would urge that while we speak about data protection, that is an area that I would want that can be addressed as a matter of urgency. Some of these devices are taking up a lot of space that could be more effectively used by staff in various departments, and I do feel that, again, the appropriate resources need to be deployed in order to ensure that the boarding of equipment takes place as quickly as possible. So, Mr. Deputy Speaker, I don't intend to detain the chamber, but I wanted to just lend my support for this piece of legislation, to commend the others who have worked tirelessly to bring it to this point, to hope that Barbadians appreciate that we have now really reached that point where we must reduce everything to writing, but also that they understand that this administration is crystal clear in its mind in relation to ensuring that the rights of individuals are respected, that they are protected, and that those persons who seek to breach issues of confidentiality and security are dealt with through the force of the appropriate legislation. So with those few words, Mr. Deputy Speaker, I'm obliged.
Obliged to you. Member for Christchurch East.
Mr. Deputy Speaker, I don't intend to be long at all. Yes, Mr. Deputy Speaker. I want to commend the honourable member from the other place, as well as my good friend, the member for St. George South, for bringing what is an entirely progressive piece of legislation into the laws of Barbados. Sir, it is not only progressive, but it is completely necessary. I listened to my friends speak in here, and we had the practical, we had the intellectual, we had the technical, we had the legal, we had the social, we had everything, sir. But I want to just bring it right down to its basics, sir. The government can do whatever the government wants to do and pass as many pieces of legislation as the government sees fit to pass. But at the end of the day, the ultimate responsibility for the protection of your personal data lies with the individual. A lot of people, sir, are not technologically savvy. I accept and put up my hand and say, I am one of those. I still have trouble with Twitter. I keep seeing my friend from St. Michael South, sir, on Instagram, but I don't even know how to get back to him on that. I accept I'm not the best. But sir, certain bells click with me when people call to ask me questions that I don't know. When I see emails coming from people, sir, and addresses that I have no clue as to what they are, I don't respond. When something comes to me saying that my bank account might have been compromised and that please enter my passcode to verify whatnot, I don't do it. But I, sir, at heart, maybe based on my years as a lawyer, I'm a very suspicious person. But sir, I know some people. I don't want to call any names. I don't want to point fingers, but chances are they're listening. They're family to me. And they will know I'm speaking about them. There are some people, sir, that if you call them and ask them for every single bit of information, once you start by saying something sounding legitimate, like I am calling from courts, not the law courts, but I am calling from courts, standards, manners, you may have just won $1 million, right? Please give me this information. So they can give you everything you ask for. They are going to give you everything you ask for. And then be surprised when negative comes from it. The point, sir, at the end of the day, we need to be careful. We are living in times like no other. Nobody has lived in a time such as this. Everything is available at your fingertips. Anything that you want to find out, sir, you can get immediately in an instant. When we went through law school, myself and many people in here, sir, when we went through law school, you did research. You had to literally go and find a book, walk down rows and rows of dusty shelves and pull a book, and then look, and if there was a cross-reference in that book to something else, you had to go and find the other book and pull it. I see the clerk nodding as well, sir. It was a laborious process. I see law students now who don't own a book, not a textbook. If there's a cross-reference in a case, it is highlighted. If you click on it, it gives you the other case, and the next case, and the next case. Everything that you want to find out is available, sir, in an instant. Google is my best friend. I ask Google all sorts of things. I'm amazed at what I can find. Actually, I'm surprised that by now, sir, the amount of times I'm in contact with Google, that Google doesn't answer, yes, Wilfred. I'm surprised. But the point is, it's all there. It gets to the point where, sir, you are recognized by what it is you're doing. And I use this is anecdotal, but sir, this is true. And for reasons of what I'm about to say, I will not even dare call the person's name. But this is true. There is someone of my acquaintance who loves to go on the internet and watch interesting stuff. That's what they do. They watch interesting, they love ladies, right? They're fascinated by the female form and they like to go on the internet watching interesting stuff. I was having a conversation with them and a third party who was saying that y'all are stressed people. You need to exercise, you need to do things to relieve your stress, you need to take a yoga. And the person was trying to convince myself and my friend that we should get into yoga. And it will help with your posture, it will help you distress you, it will make you better able to communicate and to think and to be at peace and sleep better. Sir, my friend called me doubling over in laughter. And he said, Wilfred, you would never guess what just happened. I said, what? He said, well, I went online looking for yoga exercises at home, simple yoga, beginner's yoga. And he searched it out. And the next time when he logged on, the computer spits up a recommended site about naked yoga. So it pieced together his known browsing history with his recent browsing history, and we both discovered that there was something called naked yoga. But the point is, every single thing you do when you log on is caught somewhere and cataloged somewhere. And people need to understand that the young people, I'm sorry, sir, the students who are upstairs just left. Because the young people need to understand that once you put it up there, on the net, on the cloud, it is there forever. I did a very interesting case, sir, a couple years ago that was dealing with money laundering. And the US authorities got involved when they came here, they executed a warrant against an international company, and they seized a whole set of documents. And a data recovery specialist was brought down to Barbados. So in having discussions with the data recovery specialist, the man said to me, he can recover anything. Give him sufficient time, he can recover anything. Even if you burn the hard drive, they can take what is left of it and recover the pieces or recover information that is stored on the parts that were not destroyed. So I don't think people understand that. So when you take pictures of yourself and you decide to send them to all and sundry, and I think you're being smart and hit and delete. First of all, you need to understand that there's a trash bin that you need to empty. And then if your phone backs up in that time, that those images are caught somewhere else and stored on the cloud. And even if you manage to wipe all of that, if somebody is determined enough and is an expert in the field, they can still find it. So I want, sir, our young people, while we pass legislation that's aimed at protecting people, and while we try to stop people sending or malicious distribution of images or what are clearly personal messages, people need to understand something, that the first responsibility is on yourself. Don't put it there unless you're prepared for somebody to see it. What a lot of people don't know, and how WhatsApp catches pedophiles, is that WhatsApp transmissions, so messages between people, are encrypted end to end. That's why people will communicate by WhatsApp, by sending WhatsApp messages, because there's a certain level of encryption there that protects the transmissions between, for example, sir, myself and the Attorney General if you're using WhatsApp. It also extends to the calls, but it does not extend to images. So these anomalies are there. So people think automatically that WhatsApp is safe. So anything I send or do on WhatsApp will not be intercepted by somebody. But that is exactly, sir, how the pedophiles are caught. Because the pedophiles send images. And they belong to groups. And WhatsApp and other people like that, other messaging platforms, track the usage. And they can track the image, although they can't track the exact message that was sent. So it is there for anybody who sees fit to use it. So the other thing as well that people need to be aware of, when the bank tells you that we protect your data or we monitor your credit card use to protect you against theft or somebody hacking your credit card, that is so to a certain extent. But I had an experience, sir, when I went to Miami and I went into a store. The store was DSW in Miami. And I bought a pair of shoes. And I left the store. And my wife looked at the shoes and said, I like those ones, but I like the other ones better. So I turned around, sir, and went back into the store. I went to purchase the second pair of shoes. Now, sir, I don't want to call into question my taste in shoes, but the second pair cost like $20. Expensive shoes for me. And my credit card was declined the second time. And I'm trying to call Barbados. It's a Sunday. I had all sorts of trouble getting in contact with my bank. My credit card was declined. Stop couldn't use it. When I eventually reached somebody the following day, they said that it was an unexpected pattern of expenditure. So they never had a record of me, A, shopping in DSW or making 2 purchases from the same store. You know what? I took the embarrassment of that. I took it. I accepted that because it's kind of humiliating to have your credit card declined for $20. Yes, sir.
It's too low.
I mean, we may laugh now, but you experience a certain amount of shame, and you tell people, no, but no, this is the bank, this is the bank, this is not me, this is the bank. But it is embarrassing. Sir, the exact same credit card with the exact same bank about 3 months later was hacked for about a lot of money, sir. A lot of money. And when I saw the statement, there were 107 purchases from Amazon. 100 and small ones. They kept coming in under the radar, right? 107 from Amazon alone. And I thought to myself, you blocked my card from buying a second pair of shoes for $20 because according to your records, I have no history of making 2 purchases from the same store. I had never bought anything on Amazon, but you allowed the card to run it for 107 transactions. So, sir, this was caught because I monitor what it is that goes on with my accounts.
Yeah.
But other people don't. And people have gotten very smart in what they do. People who are intent on defrauding people or taking advantage of people who are not paying close attention, just do what is necessary to come in under the radar. A lot of people that hack in to the teller machines, so they don't go for big amounts. If they're looking to fleece you over time, sir, they go for small things that you may not pick up. But it is incumbent upon each one of us, while we bank on the government doing what it has to do to protect our data, to also be responsible for our own affairs. It is a different time. So the level of vigilance that would have sufficed in my parents' time cannot suffice now. People who do online banking need to take charge and check their accounts. People who make online purchases need to be aware that every single time you use your credit card, somebody could be pimping your information. And it is not just, sir, disreputable companies or disreputable vendors. It might be a reputable vendor with a disreputable person working for them. So it may be a big, well-known company, a big, well-known store. Target got hit with credit card fraud and ended up paying hundreds of millions of dollars in it. Not because Target is a suspicious or dodgy company, but because they had a couple suspicious or dodgy people who had access to the information that Target collected. So we need, sir, to be aware of what is going on. Sir, there's also no such thing as confidentiality anymore. Confidentiality does not exist. It exists in name. There are companies who trade in collecting data, providing profiles, and sending it on, and selling the information. So, sir, there are companies that trade in tracking your credit card history. There are companies that trade in monitoring and checking your browser history. Sir, when I say there's no such thing as confidentiality, sir, we know that we pass legislation to protect confidentiality. We know, sir, that we do everything we can to protect it and put penalties in place for people who breach it. If you listen to my statement in the context of what I have already said, sir, there are people who can recover anything about anybody. There are companies whose sole purpose of existence is to collect information and sell it. There are companies whose sole reason for existing is to generate profiles based on browser history, based on location patterns. Sir, a lot of people don't know, if you have your location on your phone, sometimes if you take a picture where you are, the other person can tell not just what time the picture was taken, but exactly where you are when you took it. If you send a WhatsApp or send an email, sir, they can tell where you are in the world when that email was sent. So people who know, business people traveling often turn off the location services on their phones so that their clients will not necessarily know they're in Barbados around the same time. Thank you. Sir, the amount of people who were in Barbados over the last weekend, who I saw at parties and jumping and are responding, sir, to messages while at a party, or responding to emails, Kadooment Day itself, because they're supposed to be somewhere else, but they're doing their work from exactly where they are. And these people know to turn off their location. Nobody needs to know you're in Barbados. Nobody needs to know that you're in the Splash Party Inc. tent, the best tent.
How do you turn off your location?
The location, sir, was in Eagle Hall, terrific Telscar Park. Nobody needs to know that you were there enjoying yourself when you responded to the email about having to sell property in New York, and that's a fact. But we owe it to ourselves, sir, to become savvy with the technology. Sir, I know that you're challenged just like I am.
Yes.
I am, actually, to be honest, sir,
I don't know how to turn off the location.
sir, I actually did myself a disservice. I would say, sir, with no aim of being contradicted, that you're probably less savvy than I am. And it would be a good thing, sir, for all of us to know exactly how to turn off the locations on our. Nobody needs to know, sir, when we're doing the business of Parliament, exactly where we're seated in Parliament. The point simply, I think, if we take away the humor from it, I think the point has to be understood that we do not even understand, the average user does not even understand the capacity of the device that he or she holds in their hands. Sometimes I see my little godchildren, sir, doing things on their iPads, on their phones that I cannot even believe happen on a phone. My good friend sitting across from me, sir, I won't call her name. There's only one her sitting across from me, directly across from me, right? Had to show me something, how to do something on my iPad, and I thought to myself, wait, that can be done? She said, yes. And she said it in a very patronizing tone, sir. I was almost offended. But she showed me something I didn't think could be done, and to her, it was the most normal thing in the world. I was surprised I didn't know it. I didn't know it before. But the fact is, sir, if you think about it, Siri or Alexa, to be able, when I say, okay, Google, and Google responds, well, for Google to have heard the okay, Google had to be listening. When you say Alexa, and Alexa comes on and says, how can I help you? For Alexa to be able to respond, to invite my question, it meant that Alexa somewhere, whether actively or passively, was listening to what I'm saying. Everything we say, sir, everything we do, sir, it is being tracked by somebody. When you send your credit card information in a text, you have yourself to blame. Government can do its part. Government must do its part. And what we have done in this data protection legislation and the computer misuse legislation, other such pieces of legislation, is admirable. It is government stepping up to the plate to protect its citizens. But there's a point past which government cannot protect you if you insist on being reckless, or if you choose not to understand the technology that you're putting into use on a daily basis. The other thing, sir, companies need to appreciate and understand that they can only use data for the reason for which it was collected. So if I collect your information, sir, for the purpose of, I don't know, processing a license, that information should not be passed on anywhere unless I am made aware of it for another purpose, like soliciting me to buy a cable service or to get a new cell phone. So things, sir, the government taking steps to protect the use of the data for the purpose for which it's collected is admirable. It tends to cut down, sir, on a lot of the apprehension we may have as to where our information is going to end up. And the last thing I'm going to say, sir, this is a general warning to everybody. We lawyers trade in confidentiality. There's something called attorney-client privilege. When you tell your lawyer something, you expect your lawyer to hold on to that on pain of death and not to release it unless subject to a court order. And even so, you want your lawyer to protest and appeal that court order. The same thing with doctors. The same thing with pharmacists. There are certain professions that trade in secrecy. That the core part of their profession and professionalism is the ability to retain the information and to keep it close to their chest. Your average friend is not that person. The young people need to understand that when you take a picture or you send a message to your friend that you trust, that friend you trust may send that picture or message to another friend that they trust and say, don't pass it on. And then that person will pass it on to their two closest friends, and by the time you know it, all your information, all your business is out there. Right. It is a scary world we live in, sir. I took the time to get up today and speak because I actually want young people to hear what it is I'm saying. Young people today are not significantly different from you and I, sir. The difference with young people today is that they insist on recording everything. A lot of things we got away with as children, and a lot of things we got away with as young people, because there was nobody there to see, and there was nobody there to record, and the only people that knew as a fact were the people who were there. Right now, it is all about likes. It is all about being that person on the internet. It's all about being recognized. And people put up on the internet or share some things that a year, give them a year. Actually, give them a week until it blows up and they regret what they did. It makes perfect sense to you at 6 o'clock, Kadooment Day, when you are happy as a clam, having had the best of what Barbados has to offer in terms of distilled spirits, and you are going down the road on your last legs and you think to yourself, let me film exactly what it is I'm doing now. It makes perfect sense to you today. But you know what? Tomorrow you call in Loop News, you call in Nation, you're asking people to pull it down off their websites because you weren't thinking straight at the time. I took this time, sir, just to send a message. When we were children, we could not believe or imagine that technology would be where it is now. What we saw on TV with the Jetsons and Star Trek and all those other things, sir, those things, we are living the future that we thought was impossible. The technology that we have now, sir, that involves planes taking off and landing vertically, that can land a jumbo jet on an aircraft carrier. That technology, sir, that allows people, those hoverboards, that allow people, we've gone past jet skis now, sir. People actually have these hover things that you are surfing in the middle of the air over the sea. This is technology we thought could never happen. People doing self-propelled travel, that you can put on a jetpack and send yourself to St. Lucie. You become your own airplane. We thought that would never happen, but it is happening. And it is happening faster than we can keep up with. Right. And it is happening faster than people can understand. So my point, sir, is that technology is good. It has a purpose. It is not a toy. It is also dangerous. So the government is doing its part in this data protection bill. But citizens need to do their part as well to protect themselves. Don't depend on a piece of legislation to stop you from making a mistake that you could have prevented. So become familiar with technology, embrace the technology, understand the technology, but use it responsibly and use it wisely. For the rest of it, sir, we have the Data Protection Bill and the associated legislation to protect the citizens of Barbados, which is what we are all about in this chamber. So I wish, sir, to commend my friend, the Honourable Member from St. George South, and the Honourable Member from the other place, Senator Kate McConney. Senator Kate McConney, sir, for this most progressive, important and necessary piece of legislation. As technology improves or develops, we are going to come back with more and more, because we're going to have to put in other protections that we can't even begin to contemplate at this point in time. But we as a government, sir, are prepared to do what is necessary to keep pace with technology, keep pace with the current times, to protect the people of Barbados. Sir, with those few words, I thank you. I support the bill.
Member for St. James. Before the member for St. James North speaks, the Leader of the Opposition has advised me that he spoke on this debate as well. So he wants it to be included in the minutes. The member for St. James North.
Thank you, Mr. Speaker. This has been an extremely thorough debate in which well over half of the members of Parliament, including the Honourable Leader of the Opposition, contributed. We've had contributions stemming from high intellectuals, debate on law from the Honourable Member for Christchurch South, eminent Queen's Counsel. We've had, of course, from the practical aspect, the medical side, the Honourable Member for St. Philip North, and technical level, the Honourable Member for the City of Bridgetown. Not saying, sir, that the only intellectualism can come from lawyers at all. I said intellectual in general. It has been a worthy debate. It has been a worthy debate on an extremely significant legislative intervention by the government, by this government of Barbados. This has been the latest in a series of pieces of legislation passed by or brought to this Parliament by a Barbados Labour Party administration, starting from the early part of this century with the Electronic Transactions Act, and then the Telecommunications Act, the Misuse of Computer Act, all passed in this Parliament under the last Barbados Labour Party administration, and now this piece of legislation, sir, showing, of course, the practicality of the Barbados Labour Party and the modernization of government under this party, sir. It is not, it goes not without notice that this particular bill would have been just sitting in a ministry, probably in file 13 for the 10 years, 4 months that the Democratic Labour Party was last in office. They're not bringing any revolutionary piece of legislation on this issue of information data protection. Of course, being more interested in other things, incompetence, corruption, callousness of the people of Barbados. And one has to commend the Honourable Member of Parliament for St. George South, the Minister, for this, and of course our Cabinet colleague in the other place, the Minister of Innovation and Smart Technology, who has done a tremendous job and continues to do a tremendous job, so as I will speak to it when I speak about immigration initiatives, for bringing this act. The act is very technical. It's not an easy act to decipher. So we all accept that there's going to need to be a period before it is actually proclaimed into law, whereby the public has to be given more information on it. There has to be a public relations campaign on it. Clearly, businesses, and understandably smaller businesses, have to make adjustments to be in compliance with the provisions of the Act, sir. And I'm sure that my friend and colleague, the Honourable Member for St. George South, will speak towards those issues in his wrap-up. It was foresight for the government to send the bill to a select committee of Parliament and allow members of the public and members of stakeholder associations to come before it and to make presentations. And of course, the report of that subcommittee, sir, has been laid in this Parliament. Some of the points made before the subcommittee have been taken into account in the bill. And so this is what you call, this is what is a government of the people, sir. A government that is transparent, accountable, and involving the people, sir. Just as we have had the launch of the People's Assemblies last month, headed by the Honourable Member for Christchurch South, to involve the people in the process of legislation and in aspects of governance which affect their daily lives. Criticism or concern has been made in terms of the ability of small businesses now to adapt to the bill, to the impending legislation. There will be a cost factor, sir, but look, you have to spend money to make money as a business person. And this will help businesses become more efficient, but it would also create employment opportunities for entrepreneurs who will be experts in the data processing and collection, sir, and would therefore create opportunities for new businessmen and for innovative people to make a living. So as being said, there's no real right to privacy under our law. I mean, our Constitution in Section 11, sir, speaks towards every person in Barbados having protection for the privacy of his or her home or another property, and from deprivation of that property without compensation. Of course, subject, as every legal right, fundamental right in the Constitution under the protection of fundamental rights and freedom of the individual, section chapter 3 of the Constitution speaks to all those rights are subject to qualification, sir, subject to the rights and freedoms of others and to the public interest. And this is an expansion of that concept, Mr. Deputy Speaker. All rights, of course, are subject, as I said, to public interest, public security, national security, and therefore that's why in this bill, interest of national security trumps interest of data protection and privacy. In other words, information and data can still be disclosed where it is in the national security interest for it to be disclosed. So we're into an age, as has been said by all the previous presenters, where information technology and access to that technology has never before been at the level that it is at. Young people, sir, especially have to be careful on what they post on social media, because your whole life is exposed. And I try telling them that, sir. We know yesterday, for instance, day of fun and frolic, many pictures and images would have been posted on social media coming out of yesterday, sir. And people, especially young people, have to be careful and cautious of what they post on social media. Because as been said earlier in this debate, no doubt potential employers in many cases go on your sites and look and see essentially what is your history, both current and past, and would make decisions as to your employment based on that history. And people would lose jobs and have lost jobs because of what they post on social media. So we have to be careful about this whole scenario. This bill advances the protection of data by seeking to promote and encourage the use of information and communication technologies at all levels, and to provide more services online by leveraging digital technologies and transforming our country into a digital economy, taking a further step in that process, and to create an environment which enables the ease of doing business. So as I said, we're into a digital age, and we must use the technology to advance Barbados and to help us on the path towards developed country status, where we were going under the last Barbados administration, but where we took a backward step during the last decade, which preceded May last year. This government is committed, sir, to easing business in this country. As the Honourable Member for Christchurch West Central made the point today, we have no choice, sir, but to move Barbados back up the ladder in terms of countries for ease of doing business. We were at number 72 out of 188 odd in 2017, sir. When this administration was last in office, we went down to 133 out of the same number of countries in May last year. We creep him back up, sir. But this bill, this legislative regime, will help us in that process, sir. Because we all know that Barbados has become too difficult a place to do business. And data collection, data processing is one of the fundamental issues relating to that particular platform. The bill speaks in terms of a data commissioner who has certain duties. Functions of the commissioner will be to monitor and enforce the application of the Act, to promote public awareness and understanding of the risks and rules and safeguards and rights in relation to the processing, to promote the awareness of the data controllers and processors of their obligations under the Act. Pretty extensive functions. There are others as well. That commissioner reports to the minister, sir, who will no doubt give reports to the Cabinet of Barbados and to the Parliament of Barbados on how the Act is being monitored. There's also, sir, Section 90 provision for an appeals tribunal, a data appeals tribunal to be formed, sir. And this again will be important because you must have a right of appeal. We're not operating any authoritative, draconian government, sir. And therefore, the Data Protection Tribunal, when established and with its constitution in the schedule to the Act, a person on whom an enforcement notice is served may appeal to the tribunal against the notice, and can also, in fact, thereafter, if the decision of the tribunal is not in his favor, can appeal as well to the court. So these are the judicial safeguards which this bill also seeks to stipulate. In terms of the Immigration Department, sir, of which I have ministerial mandate, this is very important. We have heard, sir, by many speakers of the important factor of this bill in terms of it being in compliance with European Union General Data Protection Regulations, GDPR, sir, which came into force the day of our election victory, sir, last year, May 25th. And this act is in compliance with those regulations. In other words, this act is as modern as it can be. And not only the two ministers mentioned, but also the technocrats within the Ministry of Small Business have to be commended, sir, as well as, of course, the drafters of the bill. And we know that the European Union is the region in the world which has the most sacred protection of information of its citizens in the world. It has, of course, caused conflicts with other jurisdictions in terms, of course, of our Immigration Department. The Immigration Department has traditionally collected information on every arriving passenger in Barbados through these ED cards, these blue forms, white on the back with customs forms, which we are in the process of seeking to eliminate. Saturday afternoons, my colleagues, the Honourable Minister of Tourism and International Transport and the Minister of State in the Ministry of Finance, and I spent 3 hours at the airport, sir, trying to further the process of the elimination of these ED cards. We now have 48 kiosks at the airport, sir. And this is after 16 were sitting down for a year and a half in some locked room under the last administration, purchased but not in use. We've now installed 48 kiosks, a tremendous achievement within just over a year of our administration. And we're in a position now to move towards full utilization by every tourist, every passenger coming into this country of the kiosks. Immigration has assured us that these are now sufficient, even in peak period, that all passengers would be able to use this and give their basic information, so the name, of course, when you slip the passport through, so it gives, of course, all the biometric information, your date of birth, your country of citizenship, of course, your gender. And so this act, of course, is important because other countries require that we have this type of legislation to protect the data information which we collect through immigration, for instance, from their citizens. More might be required in other instances from the Europeans, and we may have a challenge in some instances there, but this is part of the process, sir. And the same way, this is the legislative platform whereby we protect information on our citizens, which is given to other countries and to parties and businesses situate outside of Barbados. Because, yes, data has to be protected, as the attorneys at law knowing here, when we, for instance, are involved in or were involved in a personal injuries case. Personal injuries was a major aspect of my practice. Sir, I'm in the latter part of my legal career. You need the consent of the victim in the personal injuries case, to get a medical report from a doctor because, of course, the information which a doctor discloses in a medical report is personal to the person. When you want medical records from QEH, you have to, the patient has to give consent, information from the National Insurance Scheme relating to lost earnings in a personal injuries case because the person has had to take medical sick leave, consent has to be given, and this is only correct. And again, this is a platform to, this now is a legislative platform to further protect that information, subject, as I said, to issues of national security. Clearly, so as I said, there has to be concerted effort for public relations on the issue, and the Leader of the Opposition, I believe in his, Honourable Leader of the Opposition, in his contribution, also spoke towards that issue, and we're in full agreement with him because we are not going to foster a major alteration of the law on the people of Barbados without giving them the opportunity to understand the act, the reasons why it is being done, and allowing those that need to make the transformation, giving them the opportunity to make those transformations. So we have to do it, sir. Digitalization. I mean, in terms of immigration, sir, the ED cards, as we know, sitting down in the thousands somewhere, sir. Sometimes you hear that immigration, sometimes you hear that at the airport. I believe some may be in central bank too for statistics, sir. But the fact is that the inboxes, sir, the making a havoc of the environment, and if you want information, who's going to go in a box now to search among hundreds of thousands to find it? I don't know. So we've moved towards the process of digitalization of the records of, through the kiosks, and said I commend the Ministry of Innovation and Smart Technology, who have been doing a tremendous job. In immigration in particular, sir, as Minister, I have to say that because immigration has been the first, I believe, of two departments that ministry has been working on the last couple of months in terms of modernization of the information and digitalization, sir. And the officers of the Immigration Department are extremely happy as to how that process has been going on. But MIS has also been doing this with other departments, and whether it's digitalization of police certificates of character so that you don't have to wait 7 weeks to get a police certificate of character. You can get it within 3 days or so, and go and get the job that you need the police certificate of character. Whereas if you wait 7 weeks now, through no fault of your own, the job gone. Whether it's the medical records, all of these are the court registry, sir. And we have to, as a government, now avoid duplication, because that is another problem, because you're giving the same information traditionally to immigration, and when now your passport expires and you have to get a new passport, immigration used to ask you for the same documents that you gave them before. Your birth certificate. Well, your birthday don't change. So why should immigration be asking for a certified copy or the original of your birth certificate again on a renewal of a passport when you have that information when you applied for your passport at age 18 or whenever it was you applied? It defies common sense. And this has been one of the reasons why it became so difficult to do business in a small island country as Barbados. And you give your birth certificate to immigration. You give it to the Electoral Boundaries Commission, your ID card lost. And the Electoral Boundaries Commission, to get a new ID, want you bring back in your birth certificate to your marriage license. I mean, sometimes you wonder why, how we reached that stage where it became so difficult. So therefore, we will have a platform, sir, where this information would be accessed by all the relevant government agencies, sir, but it will be protected. There will be platforms and protocols for the protection of this information, which is so very important. And I'm therefore, sir, in full support of this bill. We have still other work to do before it can be proclaimed, and we will do this work. But I'm happy to be part here today of a parliament that will pass this bill through the second stage of parliament, it having originated in the upper house. I'm obliged to you, sir.
You're welcome. Member for St. George South.
Thank you, Mr. Speaker. It's indeed a privilege to sit here for the last 2 days, well, not the last 2 days, but the last 2 days of Parliament, yes?
Yes.
Or the sitting of this lower chamber, to listen to contributions to this very important bill, which when enacted will become the Data Protection Bill 2019. And indeed for me it was edifying, and I heard the member for St. James North spoke to the intellectual nature of the debates, and he did mention a profession. But I want to say that sitting and listening, yes, listening, while that profession did indeed produce in this lower chamber some interesting comments and indeed food for thought, I would want to congratulate every single member of this lower chamber who made a contribution, and indeed I took notes to enhance my wrap-up, so Mr. Speaker, I won't be too repetitive. And indeed those members, and I sitting across, the member from St. Michael's South Central and the honourable member from St. Peter who came directly after my presentation, indeed those presentations I can recall were indeed edifying to me and indeed to the lower chamber. And I got comments from people outside of this chamber on speeches that were made last week when we sat. Now, we have to be mindful of, Mr. Speaker, the whole purpose of this data protection legislation. And indeed, the honourable member for St. James North, who was the most recent person that mentioned protecting the individual's privacy and the rights. And indeed, the member for Christchurch South, who spoke, and he referenced Germany, and I want to thank him for bringing in that reference, because in my studies in terms of leading up to this debate, we did not, well, I did not look at Germany, but I indeed looked at other territories, you know, Australia, I looked at Malta, I looked at Canada and Singapore, and some of those, what I call Singapore in terms of when you look at the size of the Singaporean economy, and it reflects what we indeed, as a country, what we are doing, and indeed what we are going through as it relates to data protection legislation. And I want to say to the chamber, the lower chamber, that the Joint Select Committee, and I heard persons referencing the work and the presentation made in this lower chamber, and referencing myself in terms of the capacity, small business, entrepreneurship, and commerce. But I want to say to the Lord Chamber that the chairman of the Joint Select Committee, and indeed the other members, and those persons who would have made a contribution in terms of the private sector members who would have been there at the 4 meetings we had, those persons who would have given oral presentations as well as written presentations, indeed brought the bill to this stage. And I would want to congratulate the chairman of the Joint Select Committee, the Senator Kay McConney, Minister of Innovation and Smart Technology, indeed for the sterling work that she did indeed for bringing this bill to the stage it is at. And I also want to compliment the Attorney General's office. Indeed, those drafters, and I heard him mention it, those drafters did an excellent job. Indeed, when you look at the report of the Joint Select Committee, and I would want to spend 5 minutes later in the wrap-up speaking to the submission from the bankers. And indeed, those drafters had to, within a very short time frame, take the input from those persons who made oral presentations and also written presentations to amend the various pieces of legislation to come back to the upper chamber and now to this chamber within less than a month. I think indeed we have to compliment the Attorney General's office and those drafters whom he termed all female as opposed to male and female. But this bill, as it sets out, I don't want to go back into the details because I think we did a tremendous job, but there are some areas of the bill that require some comments. And indeed, I want to look at the whole, begin with the whole cost aspect. And I heard the member for St. Peter, I think he led off with respect to the cost of complaints. And then in a brief discussion with the member for St. Michael West Central, indeed, who in my opinion should have sat on the Joint Select Committee, only from the standpoint of his experience with his organization, his present organization, who indeed are GDPR compliant and who indeed have a data privacy officer within their companies who look after the actual privacy and rights of the individual data. And indeed, that speaks testimony as to why the member for St. Michael West Central is indeed enjoying the bountiful returns in that institution that he works for at the highest level. And indeed, that is because that organization saw it fit, even though we have not yet enacted data protection legislation, that organization saw it fit. I don't know when they did it, but it is indeed part of their modus operandi and their operational duties and function to be compliant as it relates to the EU General Data Protection Regulation, what we call GDPR regulations, and to employ a data protection, a data privacy officer who looks after the processing, who looks after the dissemination, who looks after the whole aspect of breaches, who looked after data protection, impact assessment, and the risks associated with data subjects information, and also to make sure that the organization remains compliant. And why I started there, because that institution has created a level of competitiveness, and indeed that institution has created a level of compliance that will allow businesses and individuals to feel confident in doing business with them. And indeed, they have also dealt with training from the standpoint of when we enact this piece of legislation, that institution who we can use as a role model for other institutions would indeed have gone through the necessary training for its staff, whether it is a data privacy officer, a data controller, a data processor. And indeed, that is what we as a government is trying to project. And that is what we as a government will ensure when this legislation is enacted, that we protect the rights of our individuals and also our organization to ensure that we improve in the ease of doing business, and more so to make sure that we are on par with the first world countries and that Barbados can be seen as a data processing hub, a place where people can come to enjoy not only our beauty, but indeed they can do business, or they can come here to access medical services. So these are some of the things that being compliant will allow this country to indeed punch above its weight as we used to prior to those last 10 years. And I won't go there with respect to the last 10 years, because indeed coming to office, we have set ourselves on a pathway of addressing most of these issues. This data protection, work on the data protection legislation started way back in 2005. And here we are now 14 years later, looking at enacting legislation that was started by this great institution called the Barbados Labour Party when it was in office. And indeed, the member for St. Michael West, he's there nodding his head because he recognized that this institution was visionary back then, because we recognized we had to put our country to address doing business in a digital age, to address the costs associated with doing business in a digital age. And I stick on cost because you cannot, the cost of complaints and the cost of being compliant should not be borne by customers or consumers or by data subject. I think that is the responsibility of the organization. Not I think. I know that is the responsibility of organizations, whether it is the private sector or the public sector, to avoid reputational damage. And indeed, these are some of the areas that we have to focus on as it relates to selling this data protection legislation to the public, because people, and I'm going to be very candid here, because the report on the Joint Select Committee can be viewed by anyone. And thank you. And indeed, when you review the report, and it has been made a document of the House, and I guess any member of the public can review the submissions as it relates to those presentations, whether they were oral or they were written. And one of the areas that concerned me was the banker's submission, one of the points in the banker's submission that speaks to the whole aspect of the consumers carrying the cost of the bank in an effort for the banks to become a compliant institution. And indeed, that is where I want to spend a little time, because it is the responsibility of institutions, and it is part of their legal and also regulatory responsibility to be compliant, whether it is with data protection. And most organizations, and you can speak to the Honourable Member for St. Michael West Central, he can tell you he has a compliance department within his institution. And indeed, what he did was only to employ a data privacy officer who looked at the whole aspect of data protection as they do business across borders, especially as it relates to doing business within the European Union. And that cost of compliance has already been built into his budgetary costs. So in no way the large companies, and especially banks, should be seeking to pass on cost to consumers, or what I call data subjects, in an effort to what they cite as a high cost in terms of being compliant. And I say this has nothing to do with the consumer. This has to do with you avoiding reputational damage. For instance, if you do business with a company who's GDPR compliant or who has data protection laws, and for some reason, some cyber hacker, some cybercrime person gets into your database, you will become liable to the data subject and responsible for compensation as a result of allowing that data, because you have not put the necessary systems in place, whether it is the firewall, whether it is system to protect cybercrime. You will become liable. And that is what this act seeks to do, to protect individuals. So I stress the point that the banks have a duty, a care, and a responsibility to avoid reputational damage, and also to be compliant as it relates to legal or regulatory compliance with the data protection legislation as they do business across borders. Cybercrime is upon us and has been upon us for some time. And I think during my presentation in the last sitting of this chamber, I spoke to an institution, an organization in the retail sector as a result of cybercrime, who had 2 days of downtime as a result of their computerized system, and they lost close to $500,000 with their system being down. And indeed, if that is not an example as to why we ought to be compliant and see that the benefits outweigh the costs, then I don't know what we as a government can do to sell not only to the general public, but to businesses as to the importance of setting up systems. And some of these systems would require redesigning of data collection, forms online and physical, and the websites as well as acquiring additional hardware and software security systems such as firewalls and antivirus software. So there's a cost indeed to organizations to become compliant. And you cannot see this as just a cost issue, but you have to see the benefits and the reputational damage that could occur, and also the damage that could occur to your systems as a result of cybercrime. And don't let us nitpick at costs, because the costs of these large organizations are indeed critical for them to become compliant. And while I focus on costs, it is also critical for these organizations to train their staff and train persons in data privacy for organizations at all levels. Because I often heard the Honourable Member for St. Peter, he often say that and we say all, but he repeats it more than us because of his portfolio responsible for labor. And he often say that the most critical asset is the human resources. And indeed, we hear that echoing in these walls and outside of these walls on a daily basis. And you cannot seek to minimize the value of training as it relates to data protection, whether it is training persons to be data privacy officers, whether it is training them to be data controllers or data processors. It is critical for organizations and indeed for the public service. Entities like Barbados Revenue Authority, entities like National Insurance, who process a large amount of data to train persons within the institutions. And indeed, when you analyze the cost of training versus the benefits of training, and also the cost of employing 2 or 3 data privacy officers, you will understand why we are here today debating this legislation. within that institution that the member for St. Michael West Central is associated with at a high level, he has approximately, I think, 6 or 7 companies. But within those 6 or 7 companies, he has only employed 1 data privacy officer. And indeed, he is reaping the benefits of trade as it relates not only to the ease of doing business, but as it relates to the tourism product. And indeed, that is why he's in the position that he's in, a very wealthy young man as a result of his organization, and he can feel comfortable sitting, you know, in this chamber behind us, and indeed feel and dress the way that he dresses as a result of the bountiful nature of his organization, you know, and indeed that is just an example as I speak to the importance of the data privacy officer and the cost associated with implementing or being compliant that some bankers and some other institutions are indeed seeing as challenges. But I see, and I will say to the Bankers Association, to see the cost that you will incur to indeed employ a data privacy officer or 2 or even 3 as beneficial to the organization in terms of reputational damage. And that is fundamental for any organization, because any day that someone gets information from any of those banks, when we have enacted this legislation, and they're using data subjects information for what the banks have not collected that data to be used for, then the responsibility resides with the bank. And I will want them to become compliant and to put the necessary infrastructure in place, whether it is people, it is equipment, but indeed do what you have to do to become compliant, because it is fundamental. Small businesses. Some small businesses that employ 1 or 2 persons, and when you reference the EU GDPR, they don't have to employ a data privacy officer, because a sole practitioner, say doing hair or cutting hair, barber or a seamstress or a hairdresser, can indeed perform that function either solely, or they can contract out that function to someone. And indeed, it is not a requirement within our legislation to have those small companies employ data privacy officers. There are certain things that we will exempt, and indeed, the EU, micro, small, and medium enterprises in the EU need not keep records of processing activities unless it is high risk or it is a large amount. So we too give the same level of flexibility within our legislation, and indeed we need not worry. But what I can say to those small businesses, you have to be compliant with the legislation, and indeed what it does for you, it enhances your competitiveness as a company. And indeed, trading across borders, you will recognize that you will reap the benefits. And indeed, we as a government, we will have to put the necessary systems in place to ensure that we do the necessary training and we do the necessary public awareness and sensitization, and also give those small businesses and the large businesses enough time to become compliant. I heard the member for St. Joseph, he spoke about the whole public awareness campaign that is needed. And within the legislation, under the role of the data commissioner, that is one of the responsibilities of the data commissioner, indeed to carry out the necessary public awareness. And indeed, the member for St. Joseph is right. Because we can sit in here and we can do all the legislating, we can do all the enacting. But if we do not do the necessary public relations and sensitization to allow people to understand what we are doing here. Indeed, then we will be failing our people. And indeed, this is a bill, when enacted, would be a piece of legislation and an act that seeks to protect individuals. So it is incumbent upon us, our duty of care to our citizens, to give them sufficient knowledge and give them sufficient time to put their house in order. And indeed, that will be taken care of in the bill, or has been taken care of in the bill. The member for St. Michael West spoke about the level of independence of the data commissioner. And indeed, when I did the presentation in the last session of Parliament, we spoke about the various legislation that we studied in Australia, Malta, the UK, I think it was Canada. And indeed, these legislation would have looked at the role of the Data Protection Commissioner. And while we, in the bill, Section 71, seeks to give the Data Protection Commissioner some level of impartiality of the function on the Section 71, and it states that without prejudice to the generality of the functions settled in this act, and it lists the functions of the commissioner, and they're all outlined. And it also went on, for example, in subsection M, it says that he is to provide at his own discretion, his or her own discretion, or where requested to do so, advice to any minister, public authority, or person on any matter relevant to the operation of this act. And when we look at the office of the various commissioners, we will see that there's no different to what we are setting up here at home. And it is the independent regulatory office. When we studied the UK, the National Data Protection Authority, dealing with Data Protection Act 2018 and the GDPR, this role and portfolio falls within the Department of the Digital Culture and Media and Sport, what they call the DCM, and it reports directly to Parliament and is sponsored by that ministry, the Department for Digital Culture, Media and Sports. So we're doing nothing different to what is seen in the first world countries. And indeed, we went on to look at Canada and Australia. And indeed, within Australia, what they call the Australian Information Commissioner, known until 2010 as the Office of the Australian Privacy Commissioner. That too is an independent Australian government agency. And there is nothing saying that you can't have an independent government agency, but I guess the member for St. Michael West, he is speaking to what he would have seen over the last 10 years. And indeed, we as a government, the people of this country would have grown accustomed to seeing corruption and lack of transparency and lack of accountability, but we have changed that. So don't be afraid, member for St. Michael West. We have brought back some level of respectability to governance and government. So I don't think you should fear with having an independent government agency in terms of the Data Protection Commissioner, because we have everything in the act that seeks to give him that level of independence and not to be influenced or not to be regulated or dealt with a heavy hand by any minister. Indeed, it is for that data commissioner, him or her, to utilize the act when enacted to make sure that it is transparent, it is fair, and that justice is the order of the day. and that it is not done based on political preference or based on political recommendations. So indeed, section 7 of this, part 7 of this legislation, and section 70, 71, 72, 74 gives the data commissioner a level of independence as it relates to how they are expected to function and how they have been functioning within the first world countries. Mr. Speaker, the whole aspect of penalties, and indeed penalties came up for discussion, and I think I spoke as well on penalties, and I said we don't want to imprison anyone. Indeed, what we want to do is put the necessary framework and systems in place that people become compliant. But indeed, we know very well that there may be one or two persons who will seek to breach rules. And for instance, member for St. Michael West, you may have someone who is comfortable to take your data and to share with the member for St. Michael South or the member for St. Peter for reasons that you wouldn't want. But indeed, that person might be able to pay the court $500,000 or $10,000 for the breach. But that person may not want to journey to St. Philip, just above Church Village, to that institution. So we can say A, but we have to put the necessary systems in place that seek to deal with the one or two persons as opposed to the majority. And indeed, you wouldn't want any member in this Lord Chamber, or indeed any member of the public, would not want their information to be given away or to be breached or to be used for the purpose for which it was not intended to. So indeed, those are some of the reasons why penalties have been listed in here, and indeed from 10,000 up to 500,000, and imprisonment. They are fundamental to this act and the enforcement of this piece of legislation that we are seeking to bring to books. Mr. Speaker, this brings me to the last point that I will raise as I wrap up. That is about the sensitive data, the sensitive personal data. And indeed, the member for the city and the member for St. Philip North spoke on health records. And this is one of the key points of the bill that concerns us. Indeed, we would want to, while we have set certain higher standard of protection for the processing of such data as it relates to health records and medical records, this higher standard aim at protecting the fundamental rights and the privacy of patients. It also resulted in a higher burden, or will result in a higher burden on professionals in the healthcare sector who will have to comply with it. And indeed, when I read this, it brought to mind the member for St. Philip North, and indeed she spoke. But critical to this piece of legislation, we are mindful that we may have to bring to books another piece of legislation that speaks to health records and patient care, and indeed how we indeed treat with health records. That can be read in conjunction with this piece of legislation. I think that's the best thing that we should do, but I don't think that can delay this piece of legislation coming to books. But I want to recognize that sensitive personal data, persons mentioned biometrics, but I think the health records, and the member for St. Philip North laid it out practically with data going from her office or someone coming to her office with data, and then she has to send data over to the pharmacies, then she has to send data over to the labs. Indeed, she spoke about HIV records, and she spoke about the other STD records. And indeed, we have to protect individuals. And indeed, I know that that member for St. Philip North, she was speaking about protection for herself too, because someone can hack into her system and indeed take those medical records and send them anywhere, and indeed, that doctor becomes liable. And so we are putting the necessary safeguards in place. We are indeed putting the necessary compliance issues on the table with a view that those sole practitioners will adhere to the compliance issues, and the time will come that while we have engendered a level of confidence with this bill as it relates to health records, we need to take it a step further, and the proposal is to have a separate bill dealing with data protection as it relates to health records and the associated organizations who indeed process health records to be read in conjunction with this piece of legislation. Ladies and gentlemen, Mr. Speaker, sorry. Mr. Deputy Speaker, this piece of legislation indeed will allow this country to become the first country in the region in CARICOM to be GDPR compliant. And I spoke to this before. And whereas we would have seen in the Asian Pacific nations, and we would have seen in the US, there have been certain binding agreements that have been set out with data moving across borders. We as a country, we have to lead the charge in our region now. The opportunity is right. The time is now for us as a country to lead the charge for CARICOM, to create some regional regulatory system whereby movement of data across the CARICOM countries would not be a major problem. And indeed, while we do that, we have to be mindful of the nationalistic laws as it relates to data protection. Only Trinidad, who enacted their legislation in 2011, but they're not GDPR compliant. So we have the responsibility, and indeed, we will lead the charge in ensuring that our region, even if they're not GDPR compliant, but they will bring certain legislation to book and binding agreements that we indeed can trade information across borders to assist with organizations, whether it is in the public sector or in the private sector, indeed to enhance the region's competitiveness, and for us, again, to be seen as a country as punching above our weight. Mr. Speaker, Mr. Deputy Speaker, with those words, I'm obliged, and I beg to move that this bill be read a second time.
Question is that this bill be read a second time. All members in favor say aye. Those against say no. I think the ayes have it.
Mr. Deputy Speaker, I beg that you now leave the chair and the House resolve itself in committee for further consideration of this bill.
Second. The question is that I do not leave the chair and this House resolve itself in committee for further consideration of this bill. All members in favor say aye. Those against say no. I think the ayes have it.
This House is now in committee.
And on permission to call in parts. We call in the bill in parts. In parts. Part 1, clauses 1 to 3.
Madam Chair, I beg that clause 1 to 3 stand par.
Question is that clauses 1 to 3 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 2, clauses 4 to 9.
Madam Chair, I beg to move that Part 2, clauses 4 to 9 stand par.
Question is that Part 2, clauses 4 to 9 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 3, clauses 10 to 21.
Madam Chair, I beg to move that Part 3, clauses 10 to 21 stand par.
Question is that Part 3, clauses 10 to 21 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 4, clauses 22 to 28.
Madam Chair, I beg to move that Part 4, clauses 2 to 28 stand par.
Question is that Part 4, clauses 2 to 28 stand
22 to 28. 22 to 28.
22 to 28 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 5, clauses 29 to 49.
29 to 40.
49.
Madam Chair, I beg to move that Part 5, clauses 29 to 49 stand par.
The question is that clauses, what's it?
Clauses 29 to 49.
29 to 40 stand par. All
49.
29
To
to
49.
49 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 6, clauses 50 to 69.
Madam Chair, I beg to move that Part 6, clauses 50 to 69 stand par.
Question is that clauses 50 to 69 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 7, clauses 70 to 75.
Madam Chair, I beg to move that Part 7, clauses 70 to 75 stand par.
Question is that clauses 70 to 75 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 8, clauses 76 to 89.
Madam Chair, I beg to move that Part 8, clauses 76 to 89 stand par.
Question is that clauses 76
76
to 89 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 9, clauses 90 to 92.
Madam Chair, I beg to move that Part 9, clauses 90 to 92 stand par.
Question is that clauses 90 to 92 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 10, clauses 93 to 100.
Madam Chair, I beg to move that Part 10, clauses 93 to 100 stand par.
The question is that clauses 93 to 100 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Schedule.
Madam Chair, I beg to move that the schedule be the schedule to the bill.
Second, please.
Question is that the schedule be the schedule to the bill. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Report.
Madam Chair, I beg that you do now report to His Honour the Deputy Speaker passing of one bill in committee.
Question is, I do not report to the Honourable Deputy Speaker the passing of one bill in committee. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Chairman of committees have reported the passing of one bill in committees.
Mr. Deputy Speaker, I beg to move that this bill be now read a third time.
Seconded? The question is that this bill be read a third time. All members in favor say aye. Those against say no. I think the ayes have it.
Mr. Deputy Speaker, I beg to move that this bill be now passed and cited as the Data Protection Act 2019.
The question is that this bill be passed and so cited. All members in favor say aye. Those against say no. I think the ayes have it. This bill is now passed and so cited. Very good.
Deputy Speaker, I beg to move the suspension of this sitting until 20 past 5.
20 past 5. The question is that this House be suspended until 20 past 5. Is it seconded? Not seconded? Seconded. The question is that this House be suspended until 20 past 5. All members in favor say aye. Those against say no. I think the ayes have it. This House is now suspended until 5:20 today.